Hi, I'm Puyan Darian. I'm an immigration lawyer. Today we're going to talk about traveling as a tourist or non-immigrant while you have an I-130 family petition pending. As you may recall from some of my other videos, the I-130 petition for an alien relative is often the first step in this process for petitioning for a family member. It's not always the only first step, but oftentimes it is the first step. Now, let's say you are the beneficiary of an I-130. That means somebody has filed an I-130 family petition for you. You have a tourist visa or a student visa or some other non-immigrant visa, and you want to be able to travel to the US and depart on your visa while your family petition is pending. And the question is, can you do so? There are times where an immigrant family member who wants to permanently reside in the US is not able to immediately apply for adjustment of status concurrently with their I-130 family petition. Oftentimes, these family members have to file an I-130 petition first and then later on continue with the immigration process. I want to draw a distinction between a topic I've discussed in many of my other videos about whether or not you can travel when you have your immigration process pending, right? And in my other videos, I said that you generally should not travel when you have adjustment of status pending. That's a different situation from somebody who only has an I-130 family petition pending. Let me give you an example. Okay, a US citizen spouse files a family petition for their immigrant spouse. And the immigrant spouse has a tourist visa and visits the US citizen spouse in the United States regularly. But the immigrant spouse has a job working for a foreign government and cannot immediately move to the United States. So the immigrant spouse and the US citizen spouse get married, and the US citizen spouse wants to begin the filing process for their immigrant spouse. So what do? They file Form I-130, petition for an alien relative. Now, the foreign spouse, when they come to visit on their tourist visa and they enter the US airport, Customs and Border Protection will likely see that they have a family petition pending, and they will likely question the immigrant spouse about their intent. The key here is for the immigrant spouse to explain that their intent is purely non-immigrant in nature, that they're just going to visit and then they're going to leave in compliance with the terms of their visa. Right? That's the important part. The immigrant spouse should explain to the customs officer that I intend to consular process in the future. That means that the immigrant spouse does not currently have permanent resident intent, and that means that they can travel to the US on a tourist visa with the intent of a tourist. Please do not act on anything you hear or saw in this video without speaking with an immigration lawyer first, because that conversation with Customs and Border Protection can be pretty hostile and scary. So it's really important for you to prepare with an attorney before you take any action. Filing a new family petition, traveling to the US, or anything along those lines, you should definitely consult with somebody before doing any of those things.